The following podcast contains opinion and commentary protected by the First Amendment and fair use. It may also contain adult themes, adult concepts, and adult language not suitable for children. Viewer discretion is advised.
David Gingras, lawyer with flair, took on a case, thought he'd get somewhere. Laura Owens spun a tale so wild, claimed Clayton's twin said she bore his child. In the courtroom swing, they danced their plea, but the judge saw through that false decree. Paternity suit, it fell apart fast. Gingras' bold moves, they just couldn't last. 3 strikes, you're out. Gingras, hear the call. Your case struck out, watch it crumble and fall. Laura's lies, they swung and missed by a mile. 7 felonies down, no chance to restyle. Jazz it up, now the gavel's gonna slam. Gingras and Owens caught in their own jam. To the Arizona court he appealed with might, tried to turn the tide in the legal fight, but the Supreme Court said no, not today. Your claims don't hold, they're slipping away. Judge Mata's ruling, sharp like a knife, called out the fraud that cut through their stripe. No proof of twins, no truth in the claim. Gingras and Owens, they're losing the game. 3 strikes, you're out. Gingras, hear the call. Your case struck out, watch it crumble and fall. Laura's lies, they swung and missed by a mile. 7 felonies down, no chance to restyle. Jazz it up, now the gavel's gonna slam. Gingras and Owens caught in their own jam. Then the law came knocking with a heavy hand. 7 felony counts across the desert land. Fraud and perjury, tampering too, Laura's web of lies the jury saw through. Forged a sonogram, spun tales under oath. Her stories collapse, no room for their growth. Maricopa's justice, it don't play no games. Now Laura's indicted, carrying all the blame. Oh, the saxophone wails, for the truth been told. Gingras' swagger's faded, his case growing cold. Laura's dreams of victory, they're sinking in the sand. The law's got her number with the prosecuting hand. From the courtroom drama to the felony sting, this jazzy tale's got that bittersweet zing. 3 strikes, you're out. Gingras, hear the call. Your case struck out, watch it crumble and fall. Laura's lies, they swung and missed by a mile. 7 felonies down, no chance to restyle. Jazz it up, now the gavel's gonna slam. Gingras and Owens caught in their own jam. So let the trumpets cry, let the drums roll on. The tale of their downfall, forever it's sung. In the desert's heat, where the truth stands tall, Gingras and Owens, they took the big fall. Jazz it up now, let the story unfold. A courtroom caper in the key of bold.
Welcome back, everyone, to your favorite cubbyhole on the internet. We are back again with more Laura Owens stuff, and as you may have noticed, regular customers here to the cubbyhole, we had a different introduction today. And perhaps it's because I'm feeling a little bit cocky, or perhaps I'm just feeling a little confident that with a little sultry jazz tune and our reading of the appellee's response to the petition for review to the Arizona Supreme Court, that we will, in short order, hear from the Supreme Court denying Dingus the douche canoe.
The fucking douche canoe.
And his third attempt. Or is it second attempt? I guess it depends on how you count. His final attempt to try and overthrow the trial court ruling that declared that Laura Michelle Owens is a big fat liar and a fraud. So in honor of that, you have heard his song, and we will now, thanks to the efforts of victims of LauraOwens.com and others who may be supplying all that stuff, it's a community effort. It's a team effort. We try to honor everyone as much as we can here. But let's do our little read through, shall we? Before we get from the Supreme Court, the official telling Dingus the douche canoe 3 strikes, you're out. Alrighty, enough frivolity. Introduction. Owens v. Echard is not an important case. This is not to understate the meaning of this case to the litigants, whose stakes in the outcome are self-evident, nor its significance to the many Superior Court judges who labored over the underlying dispute, and who now continue to do so in the criminal division. It also does not diminish the diligent interest of public observers who have followed, scrutinized, and reported on the proceedings with voracious appetites for transparency and understanding of the legal process. None of these acknowledgments change the simple fact that Laura's appeal failed to develop any meaningful issue that this court could properly consider. A case can have substantial meaning to the parties and even the public, while having nothing to offer in developing the state's common law. The Court of Appeals found that Laura's arguments, the same she asserts in the petition for review, were not just incorrect, but were unreasonable, not grounded in law or fact, did not meaningfully address the trial court's rulings, and ignored the applicable jurisprudence. On appeal, Laura did not meaningfully challenge the trial court's substantive findings. Instead, she suggested that this paternity action somehow transformed into some other type of proceeding, and ignored that the trial court was required to sanction Owens for the costs and reasonable attorney fees Echard had incurred, caused by her misconduct. She failed to identify with any particularity what evidence supports her argument and applied incorrect legal standards. The Court of Appeals found that her unsupported and speculative allegations against the trial judge failed to meet her burden to prove bias, and that she did not challenge any of the presiding judge's rulings, denying the motion for change of judge for cause, under the appropriate standards for appellate review. The underlying appeal wholly failed to raise meritorious claims. There are no issues for this court to properly consider because they were either not implicated in the trial court's ruling or not meaningfully developed on appeal. Of the hundreds of cases vying for limited space on this court's calendar at any given time, this one simply does not rank among those with important questions of law deserving the state's highest level of jurisprudence. Reasons to deny review. The petition for review asserts 2 primary issues. 1, the application of Rule 26 of the Arizona Rules of Family Law Procedure, and 2, the standard for reversible error in family law proceedings. Neither presents a question that is both ripe and facially meritorious. 1. The record does not present a Rule 26 safe harbor issue that this court could consider on review. The petition for review reproduces a relatively succinct summary of Laura's Rule 26 argument and does not differ in any meaningful respect from what she proffered in the lower courts. Relying mostly on case law interpreting Federal Civil Rule 11, Laura argues that every litigant is entitled to an absolute safe harbor from sanctions in the form of written notice and an unconditional opportunity to dismiss the litigation. The only significant addition in the petition for review is the history of the Family Law Rules Amendment and renumbering from Rule 31 to Rule 26 in the 2019 restyling. Petition at 1011. This history is irrelevant because the trial court did not sanction Laura under Rule 26, or abrogated Rule 31, or Civil Rule 11 for that matter. The petition acknowledges that the Court of Appeals refused to even discuss any of the federal authority supporting Laura's position, but she still seems to misunderstand the reason her argument failed. Rule 26 was never the basis for the trial court's judgment and had no effect on its ability to award fees. The trial court awarded fees and costs under ARS 25-324. Court may award fees after considering financial positions and reasonableness of the parties. And ARS 25-415. Court must award fees incurred by an adverse party if it finds that a litigant violated a court order compelling disclosure or discovery. Even if Laura's interpretation of Rule 26 was correct, a thoroughly contested hypothetical, it was irrelevant to the trial court's analysis. The court was neither required nor persuaded to grant Laura's motion to dismiss her petition after Clayton filed his response and made substantive counterclaims. By rule, once a response is filed, the court may dismiss a family law case only on such terms and conditions as the court deems proper, including the resolution of any claims by the responding party. Rule 46, etc. Laura's original motion to dismiss even acknowledged this barrier, yet she failed to challenge the denial of that motion on appeal. The Court of Appeals disposed of this entire Rule 26 argument in 3 sentences. As a preliminary matter, we note that a significant portion of Owens' appellate argument relies on her incorrect assertion that the trial court ordered sanctions under Rule 26. The court expressly awarded attorney fees and costs under ARS 25, etc., etc. We thus decline to consider whether an award under Rule 26 would have been proper. Despite vehement disagreement on the merits of this argument, the topic of whether and how Rule 26 should be interpreted is not before this court. It was not properly before the lower courts either. Given its limited and discretionary calendar, the Supreme Court does not grant review to weigh in on hypotheticals or resolve purely academic debates like this one. 2. The Planned Parenthood is not open on Sundays finding does not constitute reversible error under any standard of review. Laura argues that the Court of Appeals erred in refusing to apply a structural error standard to the trial court's erroneous finding that a witness testified that Planned Parenthood is not open on Sundays. When Laura testified, she sought care July 2nd, 2023, a Sunday. Memo December 9, etc. The day of the alleged visit is only noteworthy because Laura's testimony at trial substantially changed from what she said at her deposition and in subsequent sworn affidavits. This was not a key adverse finding, and served as nothing more than cumulative impeachment. Laura has presented this argument in various ways throughout the proceedings, arguing that the inclusion of this statement proves the trial judge conducted an independent and undisclosed investigation into the facts of this case, that the finding proves the trial judge was biased against her, that she was denied due process, and that the undisclosed investigation she speculates occurred constitutes structural error. Laura frames the issue as one of obligatory judicial recusal and further contends that refusal to recuse is structural error. Neither is an accurate statement of Arizona law. In all judicial proceedings in Arizona, no cause shall be reversed for technical error in pleadings or proceedings when upon the whole case it shall appear that substantial justice has been done. The rules of family law procedure espouse the same harmless error standard. It is well established in Arizona that a due process error, if what Laura describes even constitutes one, requires reversal only if a party is thereby prejudiced. When a party challenges a judge's impartiality, including alleging extrinsic information as evidence of bias, recusal is not required without showing prejudice. Prejudice will not be presumed, but must be evidenced from the record. Laura's most recent iteration of this argument conflates an ordinary and meritless allegation of judicial bias with the extraordinary form of bias necessary to trigger structural error review. She must formulate the argument this way because she has shown neither bias nor prejudice, and she cannot succeed in her appeal under any standard that requires such showing. Regardless, she has not shown structural error, bias, or prejudice. A. Structural error did not occur in this case. First, the Court of Appeals rejected Laura's argument to apply structural error analysis because structural error did not occur. Thus, even assuming without deciding that structural error applies in family law cases, it did not occur. And the presiding judge did not abuse her discretion in denying Owens' motion for change of judge for cause. The Court of Appeals found that a biased trial judge may be considered a structural error. But Laura failed to show bias. Both the presiding judge and the Court of Appeals found that Laura's unsupported and speculative allegations failed to meet her burden to prove bias, and rejected her claims on the merits. Moreover, Laura failed to show the type of bias necessary to implicate due process rights. Although landmark criminal cases like Ring and Valverde generically refer to judicial bias as structural error, the defendant must allege a form of bias that would implicate his due process rights, such as that which is based on a direct, personal, substantial, pecuniary interest, to establish structural error. Accordingly, even if the structural error doctrine could theoretically apply in family law proceedings, the facts necessary to establish such an extraordinary defect in the trial mechanism simply do not appear in this record. This is another abstract question that may appear academically interesting, but its answer will have no impact on the outcome of the case. B. Laura did not establish bias or prejudice. The Court of Appeals also analyzed Laura's argument as a claim of judicial bias separate and apart from any structural error or presumed prejudice claim. A judicial bias claim requires proof that the judge abandoned impartiality and that the appellant was prejudiced as a result. This is the same standard the presiding judge applied when reviewing Laura's motion for change of judge for cause. On appeal, Laura did not argue actual prejudice. The record is replete with evidence supporting the trial judge's ruling, and Laura invited scrutiny regarding her alleged visit to Planned Parenthood by changing the location and date in her testimony multiple times. The Court of Appeals conducted a brief prejudice analysis, even though Laura did not properly develop these arguments on appeal. Upon finding waiver, the reviewing court could have just rejected the arguments without further discussion. Instead, the record at every stage of the proceedings shows extraordinary patience and fairness to Laura, despite persistent unreasonableness. The trial judge kept control of a difficult case, and the reviewing judges found no prejudice from one insignificant misstatement of trial testimony. When the record so thoroughly supports the trial court's conclusion and justice has been done, reversal would serve no meaningful purpose. Indeed, there comes a time when every case must end. Otherwise, the process becomes more important than the resolution. It is time for this case to end. Attorney fees and costs. Clayton requests an award of attorney fees and costs incurred in response to the petition for review pursuant to ARS 25, etc. The end. So there we have the response from Clayton Echard and the counsel therefrom. And I'm going to keep this short because it is the beginning of the week. You've heard a preview of yet another new song that I expect in short order, in due course, hopefully very soon, hopefully this week even, we will get to use again when the Supreme Court, I think, will smack down Dingus the Douche Canoe.
The fucking douche canoe.
For the last and final time for his antics, and then we will have no further need for him. In other news, we have noticed that Dingus the Douche Canoe
The fucking douche canoe.
has also indeed turned back on his Twitters. Yes, he has. And he posted, as of June 19th, that he says he's back. Yay. He still hates what X is, but it's still useful. And he also says, for now, I'm nuking all the posts about a certain case. That being Laura Michelle Owens, indicted felon. Why? Because another lawyer is in charge now. I should say so. He will decide what info to share, not me. That's the right approach, and I'm 100% supportive of it. He's absolutely ridiculous. That's all he gets. That's all the attention I'm giving him, because as soon as the Supreme Court smacks him down for one more time, and I'm fairly confident they will, I could be wrong. I could be very wrong. They may surprise us all, but somehow I doubt it, because the arguments in favor of just letting this thing be what it is and how it was decided and resolved is the right approach. There's nowhere further to go, and he would be a fool to even attempt to go anywhere else with it, because he will get laughed all the way around the universe. So that's all the attention he's going to get from us, and we may have to bid him adieu once the final ruling from the Arizona Supreme Court rolls in that we decline to hear this case. So until that time, we'll keep an eye on that. But for our next episode, we will talk about the Miley Ray Cyrus moment of Laura Michelle Owens being a wannabe country singer. I've come up with a way where we can talk about these things in a very informative, educational, a technical analysis fashion that I think should allow us to play some little snippets without inviting the evil the evil eye towards us, because it is absolutely fair use to do some analysis of things, including music, whether it be copyrighted or otherwise, which we shall do, and which happens to be in a certain part of our skill set here in the cubbyhole. So we will talk about that, because there is a lot. As if this isn't foreshadowing. Foreshadowing of more than a decade ago, of the my boyfriend's evil and this is how I'm going to get back at him type of stuff. That's what we can find in some of the country music stylings of Laura Michelle Owens, failed country music singer and failed podcaster without the help of her parents. I don't think she could have done anything on her own, but that's my opinion. All right, folks, that's enough for this evening. We'll keep it short and sweet in under half an hour. Until next time.
Why do we have to, every time Rachel says something, you're just like, oh, you're not listening. It's just I don't get it. She is listening. She's listening to every word you say. And she's presenting something, and then you come back and shake your head and sigh.
Okay. Anyway.
Submit to an interview. You can
Wow.
them.
Wow. Stop. Well, if you let me. We're moving on to the next question. We're not gonna get very far with that. So
They can prove that this is not the first time she's done it. But even if you disagree with me,
I felt like I was juggling a flaming chainsaw while having my leg bitten by a German Shepherd. Okay. All right. We're moving on to the next question.
what lawyer ever says that?
Well, you're welcome that I gave you that's such an easy way to roast me.
Allegations, you know it's a possibility you might not win something. We're talking about the
There's
appeal.
no chance you lost this appeal.
Yeah.
And you will have this.
Rachel, here,
Ever.
can I offer you like a cookie or something? What do you want me to say? What do you want me to
Not
say?
that. In our case, we like our case.
I shouldn't have said that. Can we move on? Okay.
Yeah.
Pull it up. These statutes were invoked.
Yeah. Okay. Hang on. You're getting. Okay.
But show me a case that says that, because your cases don't. I've read them all now. Just give me a quote from Holgate. Just give me a quote from Holgate that says.
Can you hang on? Can you hang on for just a second here? Okay. Lord. Okay. You are pretending. Wait. If you want me to stay on this, you need to let me have fair opportunity to answer. Okay.
David, of 58 minutes, you've probably talked for
times more than I
42 of
have.
them. I mean, come on, man.
Okay, guys.
Hold on.
Let me.
I got the
Rachel.
case somewhere.
Oh
There's
God.
only the Rule 11. Hold on. There's other authority. What was at issue in that case?
We gotta move on. We gotta move on from that.
So, is the whole point? Try to withdraw it. There were other issues before the court.
Oh, for God's sake. Okay, Steve, can we move on? Because we're not going to get.
And then you come back and shake your head and sigh.
I know,
Because
but
you don't have any authority to infringe his copy or whatever, that I interfered with his.
way before my time, way before I was there.
Way before you're there. Where are these children?
Okay, you ready?
Where are they, David? This is the one thing that I think everybody wants to know.
Okay,
She's still 6 months pregnant. Can I show my belly? How would she have a belly in November if she miscarried in July or August?
look.
It's still not appropriate for her to include that finding of fact. Where are the people? There were reasons that her findings would have been inadmissible.
My Lord. Steve, oh my God.
And then Rachel gets 5 to 10 seconds before you sigh.
Read the emails with Clayton, the emails with Greg, the text messages with Mike, 5 that it is, but something that purports to be.
Whatever.
If you would have won, I mean, obviously, if you would have won, you would have gloated too.
Here, sign something saying that you raped me, that Laura was pregnant. I don't know what that would be. I mean, she's been running around subpoenaing things, apparently.